Okay, I think we'll get started. Hello, everyone. My name is Aoife Nolan, and I am delighted to welcome you all on behalf of the Doughty Street Chambers Children's Rights Group. The group brings together barristers from across all practice teams to focus on innovative legal advocacy aimed at securing the rights set out in the UN Convention on the Rights of the Child. And we are absolutely thrilled to be here to launch this guide on effective participation and fitness to plead. And this guide is the most recent one to emerge from a collaboration of which we are extremely proud between YJLC and Doughty Street. Doughty Street Chambers would like to express our immense gratitude for the work done in authoring the guide, particularly by Shauneen Lamb in collaboration with Katja Moran and Laura Cooper at the Youth Justice Legal Centre, together with invaluable support from Doughty Street's own Daniela Wadu. And we're also really delighted to be co-hosting an event featuring such distinguished expert speakers, including, of course, our own Doughty Street Chambers, Emma Goodall Qc. Thank you very much for being with us today, and I now have the pleasure of handing you over to Katja Moran, co-head of the Youth Justice Legal Centre, who will be chairing today's event. I hope you enjoy it.
Thank you very much for that, Aoife. And on behalf of YJLC, I just wanted to say a really big thank you to Doughty Street Children's Rights Group, particularly Keelan Gallagher QC and Professor Aoife Nolan for their roles in getting us where we are today at the launch of our next guide in our collaborative series. And also wanted to express some real gratitude towards Daniela Wadu, who for her written contribution to the guide. She's a youth justice expert with meticulous attention to detail, and the help has been invaluable. And also, of course, huge thanks to Shauneen Lamb for all her work on it. It's been one of the trickier ones, I think it's fair to say. So thank you for that. So the guide that we're launching today, Richard, if you could just, thanks. There's a picture of it there, the Effective Participation and Fitness to Plead guide. I think it's fair to say that it's a tricky, messy area of law. And when we get it wrong, the impact on the children affected is really devastating. So in the guide, we have done our best to explain the relevant legal framework and give practical advice about what the defence should do at each stage of a case with these issues. Next slide, please, Richard. The Youth Justice Legal Centre are also today launching an illustrated toolkit on instructing an expert in criminal cases involving child defendants. This is obviously linked closely to effective participation, as you will be instructing an expert when you have a case around effective participation or fitness to plead. You should have been emailed links to those resources, but either way, they're available on yjlc.uk, along with all the other guides. Next slide, please, Richard. Okay, so we've got a great panel of speakers today, and I'm going to introduce the first speaker, who is Ennis Delmage, and I just need to get his bio up so that I can tell you all about him, and it's just escaping me for a moment. But here it is. He's an adolescent forensic consultant psychiatrist working in New Zealand with secure adolescent inpatient responsibility and community work, which encompasses working with young people at risk of extremist and mass casualty events. He has a special interest in children in the law, both civil and criminal, and has written a number of articles and book chapters related to the topic. He's done research into the minimum age of criminal responsibility internationally and has a particular interest in developmental immaturity and the interface with the principles of criminal law internationally in terms of mens rea, doli incapax, and fitness to plead. He's not here live, but he has prepared this presentation for us. So I'll move on to that now. Thanks, Richard.
Hello, my name is Ennis Delmage. I'm a consultant in adolescent forensic psychiatry, and I'm going to be talking to you today about effective participation in children. I live and work in New Zealand, which is why I can't be there, unfortunately, and also why this is a pre-recorded session, because the time difference was fairly prohibitive. So here is an image of our inpatient unit. It's a very lovely and peaceful setting, and here is an image of me taking some of the young people out on leave from the unit. So New Zealand, lovely place. Do come and visit when we're allowed to travel again. So effective participation is a broad topic, and I've only got a very limited time to talk to you about it. So I thought I'd start 2,500 years ago with this incident. So the chap in the armour that you can see there is Orestes, and he is killing his mother and has killed his mother's partner following her murder of his father Agamemnon, and Agamemnon was murdered by his mother because Agamemnon had killed their beautiful daughter Iphigenia in order to win the Battle of Troy via an underhand deal with the gods. So this system of justice was fairly ineffective. It was a blood for blood system, and eventually this woman got involved. This is Athena, the goddess, and she felt that this system of justice was fairly ridiculous because the end point would be that everyone died. So she decided to develop our first court, and she acted as the judge in the case. She was also the defence barrister, which I think these days most of us would see as a conflict of interest, but anyway, that was her role. And the good news was Orestes was acquitted in this case. The prosecution were the Furies, who were a sort of topless feminist militant group, and they were very frustrated because they thought he should be killed. Athena disagreed. So I thought I'd talk a bit about effective participation over the ages, and I'll start with France in 1386, and this is a pig in the dock. The pig unfortunately had killed a 12-year-old boy and was convicted of murder and found guilty in this court. The sentence was death, and the pig was hanged sometime later. It was actually a female pig, but they dressed it in boys' clothing to make it a slightly more authentic process, I guess. Skip ahead to America, 1904. This was Topsy, a circus elephant who had been mistreated for years and had gone on a stampede and had killed 3 men who were her trainers, and was again found guilty of murder and was sentenced to death via electrocution. Thomas Edison, weirdly enough, was involved in the process of electrocuting this elephant to death. The original plan had been death by hanging, but the physics of hanging an elephant are fairly challenging. And this was a case of a 9-month-old boy who has been, or was accused a couple of years ago of attempted murder at the age of 9 months, as well as threatening the police and interfering in state affairs. The case was thrown out of court, but only on the second hearing. So I have 2 small children myself, and over the years I've been trying to work out what it is that they want from me. What children seem to like, especially small children, is milk. You can see they're fairly enamoured of it and will do their best to get hold of milk if they possibly can do. What they don't seem to be particularly enamoured of is fingerprinting. And you can see there the child is fairly vocal about his dislike of the justice system that he is part of. And this is a similar case from a few years back of a 4-year-old who was sentenced to life in prison for murder. And also this 4-year-old had similarly been threatening the police, who look fairly worried by the prospect of managing this 4-year-old. So the most obvious case, I think, from my training, and I remember this case fairly distinctly as resonating with me as a training adolescent forensic psychiatrist was the Thompson and Venables case. So this was 1993 was the case was in court, and eventually ended up in the European Court in 2000. And 3 violations, as you'll probably know very well, were found at the European Court, one of which was their right to a fair trial. And Thompson and Venables were seen as meeting the standard and have been correctly assessed as being fit to plead, but were deemed not to have been able to meet a broader standard of effective participation. And the other case, which again you'll be familiar with, of note, is SC versus UK, and this was an 11-year-old boy who was charged with armed robbery and had a past history of offending. He had an intellectual disability and was thought to be functioning at the level of an 8-year-old, and also had impaired reasoning, but the judge did describe him as streetwise, which again resonated with me in terms of the judicial comments in relation to Thompson and Venables, where they'd been described as showing cunning, which in a 10-year-old again is an interesting developmental concept. So SC was convicted in Crown Court and was given a 2.5-year sentence of DPP. The application to the Court of Appeal on the basis of query fitness to plead was rejected, and the European Court, again at Article 6, said, well, SC was again probably fit to plead but not able to effectively participate to the extent required. And they went into a little bit of detail in relation to what they meant by effective participation. So SC did not have a broad understanding of the nature of the trial process and what was at stake. He had little comprehension of the role of the jury and the importance of making a good impression on them. He didn't know that he was at risk of a custodial sentence, and even after sentence, he couldn't grasp that he wasn't going home to his foster father. So, broadly speaking, what are our principles of effective participation? Well, in this context, it presupposes that the accused has a broad understanding of the nature of the trial process and of what is at stake, including the significance of any penalty which may be imposed, and that he or she, if necessary with some assistance, should be able to understand the general thrust of what is said in court. And the defendant should be able to follow what is said by the prosecution witnesses and, if represented, to explain to his lawyers his version of events and point out anything that he disagrees with. So the way that I would tend to assess it is we ask the young people to take us through the court experience from the start to the finish. So we'll say, you know, pretend that we've never been to court before, tell me what it's like, you go into the building, then what happens, and we'll ask various bits all through the process in terms of what their understanding is and the idea of what the role of the people there is, when they can speak, when they can't speak, what the potential outcomes would be, and as I said, the role of the key players and their likely disposal options. So there is another arm to this which really relates to emotional resiliency and their ability to comport themselves reasonably in a court and be aware of the impression that they're giving to the judge and any jury. So it's a complex thing to test for. Broadly speaking, individuals need to have an understanding of the charges and the potential consequences. So as I've mentioned, the seriousness, plea consequences. In New Zealand, we have a system where young people can either admit to or deny charges rather than pleading guilty or not guilty. But so it depends what level of court they're in, and have a realistic appraisal of the outcomes from the court. They need to have an understanding of their specific trial process, so the roles of the people that will be involved, the level of the court, and to have a good grasp of the general sequence of events. And as I said, that's why that kind of sequential description of what they've experienced before is often helpful. And they need to have capacity, and I tend to use the UK's Mental Capacity Act standards, so the sort of believe, understand, repeat, ponder kind of bit to participate with and instruct a lawyer in relation to the choice of defences, and this is about their ability to trust and collaborate essentially, and weigh up the options reasonably without significant interference, which may come from developmental maturity or maybe a mental disorder. and again, the capacity to challenge prosecution witnesses and essentially monitor trial events and basically flag up if they hear something about themselves which they disagree with and want corrected. So they need to have the ability to participate in the courtroom, to testify in a coherent fashion, to manage their own behaviour and essentially manage the stress of the trial and not let that interfere with their participation. These standards, as laid out, are similar to Thomas Grissot's adjudicative competence test, which you'll probably be familiar with as well. And the broad brushstrokes approach I tend to take is to include as many factors as I possibly can that I think are germane to the issue, which with children, it's a fairly inclusive group of questions. So the assessments themselves tend to take quite a long time and are fairly far-reaching. So I thought I'd talk a little bit about developmental maturity. There is no standard test for it. There are various instruments and research projects in relation to assessing specific aspects of development, but there is no broad standard developmental maturity tool recognised in mental health services, and certainly not a tool for use within court proceedings. So there isn't a standard test for it. We do in New Zealand and Australia still have Doughty packs for those aged 10 to 14. So that's a kind of proxy of developmental maturity assessment. The UK obviously doesn't have it now and hasn't effectively since 1998. Developmental maturity is not a mental disorder. So again, some of the elements that you might ordinarily think about in terms of defence related to mental disorder don't apply with developmental maturity. Nevertheless, it can still cause major difficulties in terms of fitness to plead. And the issue, I think, for us is that we're often wanting to try to avoid being too paternalistic and do everything in the best interest of the child. But we also need to recognise that in terms of autonomy, there are things that can impair those abilities in neurotypical normal children, let alone those that are in the justice system who have some pretty significant disadvantages in terms of brain development already through malnutrition, abuse, repeated traumatic brain injury, fetal alcohol spectrum disorder, etc. So there is a clear concern, I think, in terms of fitness to stand trial, fitness to plead as you have in the UK, and the broader standard of effective participation in relation to the impact of developmental immaturity. But if I meet an individual who's clearly not fit by dint of developmental immaturity, it does obviously raise questions in my mind as to whether they were able to form mens rea in the first place. And this is clearly worth mentioning if you think you can adequately back up your statement. There's not many of us that are courageous enough to stand up and make assertions on the basis of developmental immaturity. And of course, cases of high profile cases in the very young are fairly rare anyway. So perhaps it's just a lack of arenas in which to test the question. It's not a disease of the mind, so it wouldn't really fit in terms of the insanity defence. And one of the defences that we have in New Zealand in terms of the insanity defence would be natural imbecility, but again, that's normally taken to mean intellectual disability and probably wouldn't fit for a normal condition like developmental immaturity. But crimes, as far as I'm aware, still require actus reus and mens rea in order to proceed to a conviction, and this is a concern for me as to whether some of these individuals have adequate mens rea in the first place. The question in terms of fitness really is, if they're deemed unfit due to developmental immaturity, what happens to them? And presumably there's a welfare-based approach, but clearly they're not going to be the remit of hospitals because this is, as I said, not a mental disorder. So the Macarthur Juvenile Adjudicative Competence Study, again, may be familiar to some of you. This was a large study from the US involving 927 young people and 446 adults who were a comparison group. And sure enough, trial-related competence abilities seem to improve with age. The 11 to 13-year-olds showed significantly less understanding and less reasoning and recognition than 14 to 15-year-olds, who in turn were worse off than the 16 to 17-year-olds. And in terms of reasoning, the 16 and 17-year-olds were effectively functioning as adults. Those with low IQ scores were particularly likely to show deficits, and again, you'll be aware that's the majority of the customers that we get in youth court. And they're more likely to waive their rights than adults. They're also more likely to accept plea agreements. This was from the American study. And that was the case even for 16 and 17-year-olds, more likely to accept plea agreements than adults. And they tend to make choices in compliance with what they think the authority figures are looking for. And again, as you might not be surprised to learn, there are risk perception deficits and future orientation deficits found in young people, and in this study, in the case of young people facing trial. They also often don't understand the right to remain silent. They think it's conditional or may not apply if somebody with a wig asks them a question or what have you. So here's a bit of a case experience of mine. This was a chap who said, well, there were 6 of us in this big glass dock. 5 of the defendants had ADHD and it was chaos in there. The fights broke out in the dock all the time and they kept having to stop the trial to deal with the fights. He said, I couldn't see my family and they couldn't see me. And nobody helped me. The court security officers sometimes explained what was going on, but often they just tell him to face forward, and he didn't feel as anyone else he could really ask questions of. He said the trial process was 8 weeks, Monday to Friday, 8 AM to 6 PM, fairly relentless, and he felt he didn't get any real breaks. He just went to and from the cells or was speaking to the lawyer, and yeah, fairly frenetic. He said his co-defendants would ask for pens and paper and then would just doodle and draw cartoons all day, and he created a pretty poor impression on the court, and was told that he didn't care because he was looking around when people were talking. But he said, I couldn't understand what's happening, and I was just getting really bored. So I'm going to skip through this slide relatively quickly because you will be familiar with some of the adaptations that could be put in place in court. We tend to recommend a number of these, but sometimes we find out subsequently that these conditions have not been met. So it's fairly important that the recommendations are listened to from the expert witness, because in certain cases where they're not met, then the individual may be rendered unfit. And if we can't convince ourselves as professionals that these conditions can be met, then we'll often opine that they are unfit. So there are a number of adaptations that courts can usefully put in place, which can make it easier for young people to engage. We've been fairly impressed by the use of video conference, especially in these COVID days. And there are, as I said, a range of options that you can put in place to make things easier for young people to meaningfully engage. So that's it from me. Thank you for your time, and if anyone's got any questions, do feel free to email me. There's my little photo plug for New Zealand in case anyone's on the brink of making their own personal Brexit decision and coming out to visit. It's a fairly wonderful place, and this is what most of it looks like. It's great. So please do get in contact if you've got any queries. I'm happy to talk through any other issues, and I hope it's been a useful session. Thanks very much.
Well, I wish that Ennis was here with us live so that I could say thank you for that very informative and also very funny presentation. I'd like to introduce our next speaker, Greg Stewart. Greg is a partner and senior solicitor at GT Stewart Solicitors and Advocates. Since qualifying in London in the 90s, Greg specialised in advocacy and appeals involving children and young people, and has been involved with many policy issues, including the latest revision of the sentencing code for children and young people. He was called to give evidence to the Carlisle Inquiry, the parliamentary cross-party inquiry into the youth justice system, and his views were widely quoted in the final report. He's currently a member of the Youth Justice Advocacy Working Group, chaired by Mr. Justice William Davis, and the MOJ Section 28 Steering Group, and is co-author of the Criminal Appeals Handbook. He has many reported appellate challenges to unfair aspects of youth court practice, and in 2019 he received the highest possible accolade in this area, the Youth Champion Outstanding Achievement Award at the Youth Justice Legal Centre Annual Summit. Greg, I will hand over to you. Thank you.
Thank you, Katja. Hello, everyone. Firstly, I'd like to say how great it is to see that effective participation is finally being taken seriously. And I'd like to congratulate the YJLC for producing such a fantastic resource, both the guide and the toolkit. I presume most of the audience is probably well versed in effective participation issues, but it is absolutely vital we keep highlighting how central effective participation is to trying to achieve a fair trial for children and young people who we deal with in what is still recognisably an Edwardian justice system, where even with all the help they can get, I fear that many don't actually get a fair trial. Ennis has just provided an excellent run through of the guiding legal and clinical principles that override this area. So it's my job really to rely on the toolkit and take you through it. I concede I can't compete either with Ennis's wit, his use of classics, the arts and exploitation of Kiwi landscapes in my run through, but I hope to go through some practical tips and points that will help you when considering instructing an expert in effective participation. It reminds me that it's over 21 years ago that Venables and Thompson prompted the original practice direction on dealing with young people in the Crown Court, issued then by the then Lord Chief Justice Lord Bingham, which set out the steps that should be taken when young people came for trial before the Crown Court. But it has taken 20 years for those principles to bed in. And finally, we've got the Judicial College's Youth Defendants in the Crown Court Toolkit, which runs alongside the guide and toolkit that the YJLC have produced. And that came out in March of last year, March of this year. And we should all be using that to stop the judiciary paying lip service to effective participation, especially in the Crown Court, which is the most Edwardian of all the courts that our clients are going to be appearing in. We even now have ground rule hearings according to that toolkit for young defendants. And I'd like us to start looking at even limiting cross-examination or agreeing cross-examination in the way that other vulnerable witnesses are dealt with in the Crown Court. So moving on to the slides. Move fast. That is the first and best piece of advice I can give anyone who is instructing an expert in effective participation. You need to move incredibly fast, especially if your client has been refused bail, because you're going to get a very quick trial date. The pool of expertise is very small and much sought after. And if you don't move fast, you will not get a suitable expert in your case. So first thing is start from day one, getting your expert and getting a good one. Next slide, please. Sounding like Mr. Chris Whitty. Lawyers and experts, you probably know the respective responsibilities and duties of lawyers and experts. What we need to do is work together to get the best possible result for our clients. Next slide, please. Experts win and lose cases. Getting the right expert can make a significant difference to the outcome for your client, or indeed whether your client is prosecuted in the first place. So you need to get the right expert. Next slide, please. A great source of guidance in this area is the criminal procedure rules and the criminal practice direction. I can't recommend enough in criminal justice these days looking up the criminal procedure rules, criminal practice direction, even if you think you know it. There's always something in there that reminds you of something you may have forgotten. And it provides a great overview of what the court's ideal standards are when we're representing clients and how we present that to the court and to the jury. Next slide, please. Pick the right expert. Lots of experts deal with adults. Not so many deal with children and young people. There is a big difference. You need a child or adolescent expert when you're looking at effective participation. I recently had a case where, because of a trial date being so soon, I had to instruct an expert who wasn't a specialist in children and adolescents because I had no other choice, and it had a very negative effect on my case. So try and make sure you get a child or adolescent expert. Next slide, please. As you would do with any expert, it's really important that you carefully consider their CV, look at their areas of expertise, check what their previous court experience is, and look at any extra qualifications beyond the clinical ones that would make them suitable for dealing with your case. In the area of clinical psychologists, you will see those who've worked in remand centres, young offenders institutes. You will see those who have had previous experience in the criminal justice system, and they often have excellent experience and will immediately be aware of the difficulties that you will face in dealing with your client and the courts. Next slide, please. Appropriate experts are those who can stand up to cross-examination, who have an independent view, who produce good written material, but can also perform in the adversarial pit of the courtroom. So it's always worth asking colleagues, asking other experts, asking other advocates who they've seen recently, who they'd recommend. And it's often the case that new ones come through and others have perhaps passed over the peak of their best evidence in court. So you need to really shop around and get as much information as possible on who the appropriate expert may be in your case. Next slide, please. Admissibility, well, it goes without saying that the expert has to be demonstrably an expert in their area. It'll generally be a clinical psychiatrist or clinical psychologist that you'll be looking at to be your expert in effective participation cases. Next slide, please. Duty of the experts, well, that's all set out in the criminal procedure rules and the criminal practice direction, which I would encourage you to include in some form in your instructions to your expert. Next slide, please. Experts' credibility will depend very much on their performance in court and how they set out the report. The slide touches on some of the obvious, clear reference points that you will have in mind and that the court will have in mind when assessing the credibility of your expert. Next slide, please. Clearly, you'd hope that no flags or no red flags are raised when you've chosen an expert, but sometimes you will come across a bad report or irrelevant material in the expert report you receive, and do not be afraid to challenge the expert if there are areas of the report that cause you concern. Next slide, please. It's important to check all of the material. You should be looking for any relevant material that may touch on effective participation. Clearly, that means medical records, full set of medical records, which you should be able to obtain. No authoritative expert will sign off an opinion without seeing a full set of medical records unless that proves to be impossible. You would want any social services files, and you really must go through social services files if there are any in the case. You should get a full set of educational records and go through those. They can be a mine of information, any care records, any previous assessments, any other educational psychological reports, which may be in their school records, may not. It's important you consult with the family and their teachers if you can. And you may need to make consider third-party disclosure applications to get that material if it's not easy to obtain. I had a case recently where body-worn footage became important in that an expert reassessed their opinions quite dramatically on the basis of the body-worn footage of when my client was arrested. So make sure you as the litigator get hold of any relevant material and check it in case it contradicts or puts a different light on what you think the issues are. Next slide, please. Disclosing evidence, clearly you need to be fair and transparent with the expert. Otherwise, you can expect that when they get to court, the prosecution, if they prepared the case properly, will point out to the expert all of the material which you haven't supplied to your expert, which might undermine their opinion. So it's not a game. It's about fairness, it's about openness, transparency, and the fact the expert has an overriding duty to the court. So make sure they have all the material, good and bad. Next slide, please. Privilege doesn't last forever. Clearly, when you instruct an expert, all of the communications between you and the expert are subject to legal and professional privilege. However, if you serve that report because it's helpful, which will be the ultimate object of instructing the expert in the first place, any underlying material, it then goes into the public realm as far as the proceedings are concerned, and the prosecution can ask for their expert to be supplied with all of the underlying material. So, for instance, the classic one would be the proof of evidence. I would never supply a full proof of evidence to an expert in a case, because the content of that entire proof then is waived in terms of privilege. So just cut and paste the parts that are relevant to the instruction. Next slide, please. A good letter of instruction should cover all of the essential background. It should refer to the material that the expert needs to consider. It should warn the expert about their duties. And as I said earlier, my firm normally have templates for different types of experts, and I would encourage everyone to put together a template. It means that you don't miss anything and you can update it with changes in the law, but that template should set out the legal tests that you want the expert to grapple with and all the background and personal information that they need to know to be properly instructed in the case. Next slide, please. Meet the family. No matter how much emotion there is in the case, and obviously families can be incredibly stressed by someone going to court and being assessed, it's really important that you discuss these issues with the family. They may well have information that's important to the instruction, and make sure the expert has access to the family of your client as well, and any other wider family information. Next slide, please. The expert's report should be comprehensive, set out in a clear, understandable way, build paragraph by paragraph. I like an executive summary at the start sometimes, but each expert will have their own style of producing a report. The most important thing is that you make sure all of the important information is in there and that it makes sense on reading it. Next slide, please. It's good to talk. it's vital that you read, reread, and read again the expert report. You should then send to the expert your views on the report and be as candid as you like, from grammatical corrections of typographical errors, which immediately set a poor impression, which can linger in a case, right through to the legal and clinical principles that they've engaged with. You need to speak to the expert and have a thorough conversation with them. My experience is experts find it incredibly useful to have legal input from you, and they will often change the reports and amend them in a favourable way. Obviously, they cannot take out anything that would in any way undermine the credibility of the report. They cannot take out sections that are unhelpful to your client, but with engagement with you and discussion with you, then paragraphs can be amended and changed in a way that is helpful to your client without in any way changing the expert's opinion. Next slide, please. Clearly, the expert will either agree, disagree, or partially agree or disagree with propositions you put to them. It's important as part of that dialogue you have with the expert that you try and shift them along the spectrum if it's possible to do so without misleading anyone in any way. Next slide, please. We set out the expert declaration in our template, instructions to experts. A lot of experts these days are aware of the CPR and the Criminal Practice Direction declaration as to previous cases and their expertise. Next slide, please. You should serve any expert evidence as soon as you're able to. You're under a duty as a litigator to do so, and it avoids problems with the trial judge later. So again, speed is particularly important in these cases, and try to serve your expert evidence in a perfected state as soon as you can. Next slide, please. As you will know, there's often joint statements directed these days where experts from either side get together and agree common principles and common conclusions, which can be useful if the prosecution do have your client assessed. Next slide, please. Often it'll be the prosecution who'll be trying to challenge your evidence in court rather than you challenging the evidence, because with effective participation, you will probably be running the show in terms of the expert evidence yourself. But be mindful of how the prosecution might try to attack your expert in terms of lack of disclosure, and often that's really not having all the material in the case, particularly interviews by your client. So be careful to make sure anything your client has said in the case is made available to the expert. Next slide, please. We've all been to courtrooms where what appears on paper, a great expert report, ends up far from it. So it's important that you know that your expert can present in court confidently and in a non-dogmatic but forceful way. Next slide, please. Spade work. It can't be emphasised enough, as with most aspects of criminal justice preparation. Get it right first time is a mantra from the Court of Appeal. You've got to do the spade work. You've got to get the relevant material. You've got to get everything you can to put before the expert, because it may make a material difference to how they assess your client, and their assessment of your client may stop the case even reaching a courtroom for trial in the first place. Next slide, please. As I've already touched on, letters of instructions should be comprehensive, have a template, use it, update it, and make sure the most recent legal principles are explained in simple terms to the expert. Next slide, please. So that's the end of my quick guide through the best practice that we would like to implement when trying to instruct an expert. It's vital for the subject of effective participation, and I certainly commend the guide and the toolkit that the YJLC have put together. Thank you very much.
Thank you so much, Greg, and that was really, really informative, and we hope that you do use the toolkit as well as the guide. I'd like to introduce our next speaker, Emma Goodall Qc. Emma Goodall Qc is a leading criminal practitioner at Doughty Street Chambers and a recorder appointed to sit in the Crown Court. She has extensive experience defending in trials involving homicide, serious organised crime, terrorism and sexual offences. Emma is also regularly instructed in an advisory capacity pre-charge in criminal appeals where she did not act in the first instance, applications to the CCRC and in judicial review proceedings. Emma has developed a particular interest in the representation of children and young people within the criminal justice system and the legal and practical issues that impact upon effective participation. She's extremely skilled at dealing with vulnerable and mentally disordered clients and experienced in conducting fitness to plead hearings. So thank you so much for joining us today, Emma, and I'll hand over to you.
Thank you. Thank you very much. Good afternoon. Although the youth justice population has changed significantly over the past decade, with the number of children entering the system having decreased by approximately 85%, those who are coming before the courts tend to have very complex needs. And they're not only deemed vulnerable as a result of their age, but often have additional vulnerabilities, including mental health or communication issues. And children and young people are also increasingly being prosecuted for much more serious offences. So as of August of this year, there were 550 young defendants aged 18 and under in detention, and 246 of those were on remand. So consequently, a high number of children and young people are attending court hearings and trials from a custodial setting. Can I have the next slide, please? Given the low age of criminal responsibility in our jurisdiction, which is a whole nother debate for another time, very young children can be subject to prosecution, and this, combined with other vulnerabilities, gives rise to significant challenges to accommodate them when they're required to be tried in the Crown Court system. And I'm approaching this issue on the basis that they've passed the fitness to plead test, and it's the recognition of the requirement of effective participation that I'll be concentrating on. And that's been identified in the ECHR jurisprudence in the very well-known cases of V in UK and SC in UK that have already been touched on in earlier presentation. The explanation of the concept of effective participation in SC has essentially been replicated as the definition provided within the Equal Treatment Bench Book. And what's required is that defendants should be able to maintain a level of general understanding and active engagement throughout the trial. They don't need a perfect engagement, and they don't need to be able to understand every point of law, but they must have a broad understanding of the proceedings and a comprehension of the general thrust of what is said in court, together with the specific requirements such as understanding the significance of any penalty and an ability to understand what is said by the prosecution witnesses and instruct the lawyers. The next slide, please. So what are the duties and responsibilities of an advocate representing a young defendant? Well, the Bar Standards Board requires an advocate to undertake specific youth justice and vulnerable witness training when appearing in the youth court, and that obviously should extend to the Crown Court. And there is a lot of very useful literature, not least the fantastic YJLC guides, which are listed at the conclusion of this PowerPoint. And as has already been touched upon by Greg, representatives should gather information from school, parents, yacht, CAMS, previous reports. There's a whole host of information that can be obtained. And from there, instruct specific experts such as psychiatric, psychological, and get intermediary reports. And in conjunction with the relevant professionals and appropriate adults and family, and indeed the young person themselves, you need to identify the relevant needs and preferences. And you may find that there will be tensions between the young person's preferences and the professional recommendations that you will ultimately have to navigate. For example, a young person may not want to sit in proximity to their lawyer. They may prefer, if they're in a multi-handed case, to sit in the dock with their friends. Equally, they may not want to be singled out by having the assistance of an intermediary. So these are issues that you're likely to have to grapple with. As the advocate, you're required to inform the court of any potential impediment to effective participation and to apply for tailored adjustments and special measures. And you should use the underpinning principles of welfare and best interests of the child in order to frame that application. Next slide, please. The clear duties of the court to protect the defendant's Article 6 rights are set out in the criminal procedure rules and the criminal practice directions, which I'm sure you're all fully familiar with. But they require the court to take every reasonable step to facilitate the participation of any person, including the defendant. And this involves ensuring that a defendant is able to give their best evidence and enabling a defendant to comprehend the proceedings and engage fully with his or her defense. And a careful and continuing case management will be necessary throughout the life of the case in order to ensure that the court meets the aims of the CPR and the CPD. Can we go to the next slide? This slide lists a number of issues to give consideration to pre-trial. Most are fairly self-explanatory, but I'll just deal with a few. First of all, the PTPH form. As a result of the Court of Appeal comments in the judgment of Grant Murray, a checklist has now been provided in the PTPH form. And I wonder if you can just skip forward 2 slides. They're slightly out of order to show that checklist. Thank you. This list has largely been extracted from the criminal practice direction. But the reality may be that there'd be insufficient information available for the judge for the whole suite of trial directions to be capable of being decided and given at the PTPH stage, in which case the court would direct the defence to serve a note by stage 2 with various welfare information and to attach any relevant reports. And that would essentially form the application for adjustments and special measures. Sorry, can you go back 2 slides now, please? Thank you. So those issues could then be dealt with at a pre-trial ground rules hearing, and it's deemed good practice to hold such a hearing, even in cases where there hasn't been an intermediary nominated, because during that hearing, a note can be formulated, decisions can be made by the judge, and there can be a clear framework put into writing for governing the trial. If there is to be an intermediary application, that should be made as early as possible, because if it is going to be the expert view that an intermediary is required either during the currency of the trial or for the purposes of the young person giving evidence, then it may be the case that such assistance would be necessary during the case preparation. So that is an issue that needs to be considered at a very early stage. Can we move now to the next slide? Now, this is a very dense slide setting out the relevant adjustments and measures that have been identified within the criminal practice direction that can be put in place. Now, a judge is required to give reasons for any departure from the applicable provisions of the criminal practice direction, and factors that will influence appropriate directions are a number, but they all come to context. So firstly, the complexity of the case, also the specific age and identified vulnerabilities of the defendant, whether the young person is appearing in custody or on bail, potentially the security arrangements of any one particular court. And for example, the logistics of the Old Bailey are likely to present with additional challenges because of the way that court is set up. Whether within the trial process there are going to be co-defendants, particularly adult co-defendants. So for example, if you're dealing with a case where you have two 12-year-old young people being tried for murder, the court in those circumstances is likely to try and facilitate security arrangements to enable them to sit outside the dock with the appropriate assistance and to have them proximate to their legal representation. But by comparison, where there is a 16 or a 17-year-old appearing in custody, jointly tried with adult defendants, then different security arrangements may have to apply. You may also find in those circumstances, particularly if you are dealing with cutthroat defences being advanced, that co-defendant advocates may try to argue against some of the measures that you are proposing for your young defendant due to their perceived presentational optics for their client. Another area that you may get resistance from co-defendant advocates on, even if entirely unattended, is the requirement that the whole trial is conducted in clear language so that the young person can understand. Advocates are often utterly incapable of achieving that, for example, when questioning expert witnesses or making legal submissions. So you will have to keep the issue of communication constantly under review during the currency of the trial. It's obviously essential that young people are appropriately questioned if and when they give evidence, and that should be dealt with specifically at a further ground rules hearing, when the parameters and the length and the division of questioning, if there's going to be multiple persons questioning the defendant, can be set and then incorporated into a referable note so that you can ensure compliance by all parties. Now, the adaptions contained within the criminal practice direction are not exhaustive. The court has inherent powers to consider additional directions. And so you must find out from the professionals and your client what else would assist. And it's important that the process is as bespoke as it can be to the particular young person. And there are a number of areas of practical assistance that, with the evidence and the procedure, that you as an advocate can deploy. For example, creating some form of timeline documents that may assist the young person to navigate the evidence, to make jury bundles more accessible through headline summaries or post-it notes, and just simply to try and establish routines to manage expectations. They're very obvious devices that can ease the process. Also, judicial directions, depending upon the measures that are imposed, consideration will need to be given to whether any judicial explanations, directions need to be given to the jury, what form they should take, and when they should be given. And again, co-defendants may seek to influence those directions for their own ends. So you've always got to be alive to the overall different requirements that are going to be generated within the courtroom by co-defendants. So will these adjustments work within the remit of a Crown Court system? Undoubtedly, they will assist, but there still remains a lack of any empirical research on their effectiveness. So it does impose a very considerable responsibility on the legal team, on professionals, and on the court to review and respond to the engagement of the young person at every stage of the proceedings, and in particular during the currency of the trial. Now, that's been an extremely speedy run through various issues that may arise, but thank you very much for your attention.
Thank you so much for that, Emma. A very large amount of information squashed into a short time, so I really appreciate that. I'd like to introduce our next speaker, Ike Stevenson, who is the legal director at Just for Kids Law, which she founded 15 years ago. Just for Kids Law, she runs the criminal team there. It was the first UK charity to hold a criminal legal aid contract. She represents numerous children and young people in the police station and at court, and is driven by a determination to bring about systemic change that benefits all children and young people caught up in the criminal justice system. Ike has pioneered employing cutting-edge arguments to ensure she gets the best possible outcomes for her young clients, and is specialised in representing children with special educational needs, and regularly runs effective participation arguments as part of her practice. So to tell us a bit more about that, I will hand over to Ike now. Thanks.
Thanks, Katia. So my involvement really in this seminar was really to sort of add any kind of practical points that I could, and advice that I could give to running these arguments in court, because we all know that, we may have procedures in place and legal arguments we can make, but the reality of actually trying to run these arguments can be very difficult. So I was very keen in all of my discussions with Katia that this guide did actually give practical advice so that practitioners can see what they can actually do. And everyone that's spoken so far has given some practical advice, so I don't plan to repeat myself. There's just a couple of things that I wanted to pick up on. So in relation to instructing your experts, I just wanted to say, be bold in your requests. Tell your experts that they don't need to be limited to their expectations as to what is possible. It's easy to feel constrained as practitioners as to what appears to be possible because of the court system. We all get very used to just the way that things happen. And often you can become complacent. I've been guilty of that myself in actually challenging these things. And I recently had a case of a young man who was fit to plead. He was charged with sexual offences, but he had a severe anxiety disorder. And when speaking to the experts, she said, well, what I'd really like to say is he shouldn't be in the room at his trial. I think that is really the only way you're actually going to contain his anxiety. And now obviously my starting point for that was fairly confused, but actually obviously, vulnerable victims are not in the room all of the time, and they're giving evidence via video link. So we made an application to the court for this client to not actually come into the courtroom at all during his trial. We asked for him to be in a room in the court building with both of his parents for the whole of the proceedings. And initially it was met with some confusion, but once I reminded the court of their duties, they did actually grant the application for special measures. We didn't actually get to trial because the Crown reviewed the case and decided it wasn't in the public interest to proceed. But if I had been fixed in, my expectations of what is the usual practice in court, then that would never have happened. And I think that that's what we need to continue to do, is to challenge ourselves and actually say to the experts, well, you are the expert in what this young person needs to be able to participate. And if they took that young person out of the court process and they were simply trying to engage them in therapy or any other kind of process, what kind of tools would they use to ensure that that young person could engage? And they would be probably entirely different to what's offered in court. And I think it's about being open to that and asking experts to be bold in what they suggest is possible. And then it's about us trying to make that happen. There have been situations where experts have provided, because of their maybe lack of understanding as to what actually happens in court, is where they've deemed a young person fit to plead and able to effectively participate, but said that they require special measures. And then they've not gone on to recommend the use of an intermediary, but they've listed a long list of ground rules and sort of ways of working and ways that need to be established in the court in order for this young person to be able to participate. And in those situations, I've had to go back and explain to experts, well, who do you think is going to do this? If you're not recommending an intermediary, then who is going to sort of manage the court in this way? And that has then meant that they have then gone on to recommend intermediaries, because it's a lack of understanding as to the capabilities of all of the people who are actually in the courtroom. In relation to clarity of the process, it's always much better to seek the court's agreement in advance as to what process you will actually be following. So is this case going to be a trial of the act, or is it going to be a trial with special measures? And that may sound obvious, but there have been situations, and the case of P alludes to the fact that you can switch during trial to a trial of the act. Now, obviously that isn't recommended, but I have had situations where that has actually happened. So if you're in the situation where you have a client who is borderline in terms of their participation, and it may actually be the court process that could trigger any of the sort of any anxiety or PTSD that is the thing that is going to make them be unable to participate, it's really important that you remain alive to their participation throughout the proceedings, because it may be that you start the case and it's a trial, then something occurs during trial and your client has either detached from the process, is no longer engaging, has had a panic attack, and their ability to participate then changes at that point. And it's very important that you remain alive to that, which is why we would absolutely advise, where you have a client who is borderline in terms of their ability to participate, to actually apply for certificate of counsel, because it's impossible if you're doing advocacy, particularly in a youth court trial, that you can actually be completely on top of what is happening with your client. And obviously this is difficult within the limits of legal aid, but I think, you know, we have had many cases where certificates of counsel have been granted, where essentially that you need to have somebody in the room who is aware that the client is no longer engaging in the process and is no longer following the course of proceedings. Sorry, I've got a frog in my throat. And then finally, we have to police the adherence of special measures. This is extremely important, and Greg is well aware of this because of all of his appeal work. So we have to find innovative ways of making sure, despite the funding limitations, that everything that has been suggested by the experts is actually happening. It's easy once a trial has started with co-defendants and everyone else working at their pace and the judge's pace and all of the different constraints, to lose sight of what has actually been agreed. And it's very important that we are ensuring that that happens. And it's, you know, even more so when you're potentially could be lodging an appeal because your client's been convicted. So finally, because I'm not sure I'm going to be able to speak much more, we held some focus groups with young people not too long ago, and even the young people who had no diagnosis, didn't have learning difficulties, or, you know, any sort of documented issue with that would hinder their ability to participate, they all said that they found it extremely difficult to participate in the court process. And so, following on from what Greg said, the system is not fit for purpose, and we need to use every tool we have to make it so. I think I'll finish it there.
Thank you. Sorry, I was both listening and worried that you might not be able to breathe in the last moment. So thank you so much for that, as ever. Just brilliant practical advice for actually pushing boundaries and sort of making real change when representing children. If I could just introduce you to our final speaker, Dr. Miranda Bevan. And I will tell you a bit about Miranda, who is a lecturer in law at Goldsmiths, University of London, and visiting fellow in social policy at the London School of Economics and Political Science. Miranda has a legal background, having practiced as a criminal barrister at Two Head Court before coming to academia. She's also worked at the Howard League for Penal Reform as a policy associate, and the issue of effective participation was central to her work recently, when she spent 2 years at the Law Commission as a lawyer with responsibility for the Unfitness to Plead report, which was published in 2016. And most recently, her doctoral research has explored the experience of children and young people detained as suspects in the police station in England and Wales, focusing particularly on their ability to participate effectively in the police interview and other investigatory processes. So thanks so much for joining us, Miranda. I'll hand over to you.
Hello, everyone. Thank you very much for having me, and congratulations on the guide. Katia asked me to speak a little about the Law Commission's proposals for reform. And so that's what I'm going to focus on, in particular on the Youth Court. I should stress that I'm a lecturer at Goldsmiths now. I'm not part of the Law Commission team, but as Katia mentioned, at the time of the publication of the report and for the last 2 years of the Unfitness to Plead project, I had responsibility for the project at the Law Commission, working with David Ormerod. So can I have the next slide, please? So I wanted to start just by explaining a little about the Law Commission's overarching approach. The original project had really focused on the Crown Court and the unsuitability, as it was perceived, of the unfitness to plead procedures that operate there. So the satisfactory nature or otherwise of the test, which dates back, as we know, to 1836, the appropriateness of the procedure for the fact-finding process that follows, and then whether the disposals that are available and the appeal processes are suitable. But as we worked with the responses to the initial consultation paper and put out a further issues paper, we became more concerned with what's happening for children and young people, and particularly what's happening in the Youth Court, where there are significant issues in respect of effective participation. So that became a substantial focus. But the overarching approach that the Law Commission took was that we should try to avoid removing defendants from the trial process unless it was absolutely necessary and in their interests, their best interests, because they lack the capacity to participate effectively in the process. And so we took the approach that every effort should be made to give the defendant who has participatory difficulties what adjustments they need so that they could engage in trial and for them to have a fair trial. We felt very strongly that there should be comparable protections for defendants across the magistrates and Crown Court, magistrates including, of course, the Youth Court. And as Ike has made some reference to already, and many of you will know, the unfitness to plead procedures are confined to the Crown Court. Technically, they don't have any application in summary jurisdiction. And I'll come on to that in a moment. And we also felt strongly that young defendants should enjoy, at the very least, comparable rights to those afforded to adult defendants. We felt that that wasn't the case at present. Next slide, please. So we made kind of general recommendations about effective participation, and then more specific recommendations around the test and processes that should apply where an individual is unable to participate effectively in their trial or are unfit to plead in the kind of terms of the current law. And I say effective participation because we really sought to reframe the rather archaic language of unfitness to plead and to draw together the kind of principles of effective participation so that we would have a test that asks whether the individual was able to participate effectively in a trial rather than unfit to plead. So we made some general recommendations which related really to ensuring that those who do have participatory difficulties are assisted to the greatest extent possible. And we focused in particular on the lack of equity between the provision for defendants and that for vulnerable witnesses. And so we made several recommendations that are of a more general sort, in particular looking at intermediary support, which, as you will know, that for which there is no statutory entitlement for defendants at present, or at least none that is in force. And so we made recommendations that the current provisions should be brought into force and amended to broaden their effect. And in effect, that there should be a statutory entitlement for defendants to have the support of an intermediary for the whole of the trial, where that is necessary to ensure that they have a fair trial. And those who have instructed intermediaries for the defence will know that it's very problematic at the moment how the provisions are arranged. We also wanted there to be mandatory specialist training for lawyers and judiciary on a range of issues, touching on awareness of participation difficulties, the appropriate mechanisms to address, and then for those who are trying youths in any court, more specific training about their common participation and communication difficulties for children. And we also wanted there to be screening for all young people appearing for the first time in the youth court, for screening for participation difficulties. So often issues surrounding unfitness to plead also come along with challenges in terms of the identification of those difficulties. Can I have the next slide, please? So, but turning to more specific recommendations, as Ika made reference, there is the unfitness to plead procedures don't apply in the youth court, and there's sort of rather ad hoc processes that function there, where a young person is having participation difficulties and might be, in Crown Court parlance, unfit to plead. And they're most unsatisfactory, or that we felt that they were at the Law Commission. So the options for the defence, as many of you will know, are fairly limited, and indeed the options for the court are fairly limited too. So if, having obtained your fantastic expert report following the toolkit, you can persuade the prosecution, for example, that the matter should be discontinued because of the extent of your client's difficulties, all well and good. But if that's not the position, then what then can be done? So the options really consist of, well, two broad approaches. Firstly, to seek a stay, but that will always, as we know, be an exceptional remedy. There's a complex process set out in the case of P by which a stay is sought in the magistrate's court, the idea being that one embarks upon the trial and one sees how the young person is or isn't able to participate before arriving at a judgment as to their ability or otherwise to do so, and only thereafter to move to consider whether they can fairly be tried or not. But of course, stays are exceptional in any event, and they don't enable any supportive arrangements to be put in place for that young person. The alternative, and indeed where the court conclude that the young person on the balance of probabilities can't participate effectively, can be that the court can switch, as Ika mentioned, to a fact-finding process under Section 37(3) of the Mental Health Act. But the difficulties with that process are quite numerous and quite significant. Firstly, it's only a process that's available if the young person suffers from a mental disorder in the terms of the Mental Health Act and is appropriate to be dealt with by reason of a hospital order, or a guardianship order. So it focuses on mental disorder, so it has very limited application to lots of those issues that young people will be presenting with potentially who have participation difficulties, such as learning disability and other communication and developmental disorders that might not necessarily fall within the Mental Health Act. This process is only applicable to imprisonable offences. And as I've mentioned, the disposals are really limited. It's very unusual for a hospital order to be appropriate for a young person. And guardianship orders are vanishingly rare. They're only available where the defendant is 16 years of age or over. So there's no supervision order or similar disposal available, and the court isn't entitled to discharge the defendant, although often they feel that they have no alternative but to do so. The procedure itself is problematic, as it is in the Crown Court, where an individual is found to be unfit to plead. It focuses on the act and not the mental elements. There's a limitation on the extent to which a defendant is able to engage defences, for example. So it's a problematic procedure as well. Can I have the next slide, please? So what is it that the Law Commission proposed? Well, in general, for the unfitness to plead regime across the courts, what was suggested by the Law Commission was a statutory test rather than a common law test of capacity for effective participation in trial, and that test would involve many of those relevant capacities that are set out in the effective participation case law SC, for example, and would also ask whether the individual had decisional capacity as well. The Law Commission also proposed an amended fact-finding procedure which would require the prosecution to prove all elements of the offence, that this process would be applicable in all criminal courts, but of course there would be procedural adaptations considering the summary jurisdiction. Quite controversially, the Law Commission proposed a separate test of capacity to plead guilty. The issue there being that if an individual was found to lack the capacity to participate in trial because they were unable to participate and engage with a lengthy and ongoing trial process, would they necessarily be removed from and prevented from entering a plea if nonetheless, despite their inability to engage with a lengthier trial process, they did have the capacity, according to the experts, to make a decision about their plea? You know, should they have to go through an alternative process if they wanted, for example, to plead guilty? So that was a novel change proposed by the Law Commission. We also proposed changes to the expert evidence requirement. So you might know in the Crown Court, you need 2 registered medical practitioners, one of whom is approved in respect of mental health issues. But as you will know, and as we've discussed already, often that expert will be a clinical psychologist who didn't satisfy the requirement for 2 experts, which meant a proliferation, or means currently a proliferation of experts often. So we wanted a psychologist to be includable as one of the 2 required experts. We felt that district judges, that these cases should be reserved to district judges for determination and for subsequent procedures where they occur in the youth and magistrates courts. Can you put on the next slide, please? And we felt there should be a judicial discretion. So at the moment, if you're unfit to plead, the court must proceed with the fact-finding process. Whereas sometimes, for example, potentially in the case of Lord Janner, for example, who was significantly incapacitated by his own ill health, the question might reasonably have arisen if he had lived, as to whether there was purpose in proceeding to the fact-finding stage, given that disposals would make no difference to the outcome for the public. That's a debatable position, but we felt that that discretion was important to build into it, that the prosecution should have to prove all elements, as I've said, and there should be a wider range of disposal outcomes. So there should be the availability of a supervision order, which had both some constructive elements as well as the medical elements that more commonly are engaged, that an absolute discharge should be available, and that there should be a hospital order, but it should be limited to imprisonable matters, with a power to commit to the Crown Court for over 14s. Can you put on the next slide, please? So big question is, well, what progress has there been? These recommendations were made in 2016. We had there was a government interim response, which said this was all very balanced and helpful, but there was no room in the next legislative window, and no formal response has been received. In respect to the youth court provisions, the government's interim response said that they would await the Taylor review. But the Taylor review of the youth justice process didn't really make any reference to the Law Commission proposal, save in respect of training for legal practitioners, but otherwise no particular comment. More recently, some of you will know that the white paper reforming the Mental Health Act has made reference to returning to the Law Commission's recommendations, and in particular in aligning better the Mental Health Act provisions for the Magistrates Court with the Crown Court. Can you put on the next slide, please? The judicial response has been more positive, and a number of subsequent cases on unfitness to plead have endorsed various aspects of the proposal, particularly moving from talk of unfitness to plead to framing the test as one of a capacity to participate effectively in trial. With regard to the more general provisions and recommendations in respect of support for people with participatory difficulty at trial, we've had more troubled progress, and I've listed here a couple of recent judgments in respect of intermediary access. We're not as far along as we would have hoped, although there is indication that registration for defence intermediaries may be on the horizon. The Equality and Human Rights Commission have also more recently last year endorsed, or earlier this year, endorsed in their Inclusive Justice report the recommendations that we made in respect of intermediaries and special measures. So some progress, but we haven't got far in terms of legislative change for sure. And the next slide, please. Katya also asked me just to touch briefly on the defence of not criminally responsible by reason of developmental immaturity. Ennis made some reference in his talk to this question. As you may be aware that the Law Commission in their Insanity report proposed, or well, it was a discussion paper, proposed the question of whether this should be a subject for discussion, whether there should be a defence of not criminally responsible by virtue of developmental immaturity, where a defendant wholly lacked certain relevant capacities, and these were framed as being able rationally to form a judgment about the offence, appreciate the wrongfulness of it, or control their physical acts in respect of the alleged offence. So that was proposed for discussion, but that aspect of the Law Commission's work hasn't been carried on. So whether insanity and automatism, that niche area of the law, will be included in the Law Commission's next programme of reform, it is in doubt. I know that various experts have requested that it be so, but I don't have any realistic expectation that that will be revisited immediately. And the last slide, please. And indeed, there is a significant question as to whether there is political appetite for a defence of that sort. The Law Commission proposed a partial defence based on impairment caused by developmental immaturity in relation to their recommendations in respect of diminished responsibility back in 2006. And the government did not accept that proposal, given that the amendment to that partial defence by the Coroners and Justice Act didn't implement developmental immaturity, and indeed required the recognised medical condition, which would kind of outlaw running a defence in respect of developmental immaturity. So that remains on the horizon potentially, but there doesn't seem to be much political appetite for that at present. So that a whirlwind tour of the Law Commission's proposals in respect of effective participation and views. Thank you very much.
Thank you so much for that, and Miranda, and thank you so much to all of our speakers. Unbelievably, we haven't actually got any time left for any questions, which has not happened before at one of these seminars, but I think it's because all the presentations were just so informative and really just brilliant, and it was great to bring so many different practitioners together who have different sort of areas of expertise, and I think we've had a really good full discussion on effective participation and fitness plead. So I want to say a huge thank you to all the speakers. Please do use the guide and the toolkit. They're designed to be used in a practical way. So thanks for listening, and we'll catch you next time in December. Thanks a lot.